I'm Marissa Cerrone, and for my final presentation, I decided to look at the issue of corporal punishment and what that means for various legal aspects of corporal punishment. When looking at this definition, I decided to look it up. Like if you go and you just Google, type in corporal punishment, this means punishment that involves hitting someone or physical punishment. I thought that that was definitely absurd that that was the actual definition from the Merriam-Webster online dictionary, just because I feel like, and other people, this is the contrary view, the negative view of corporal punishment, is that this doesn't belong in schools. Hitting someone is against the rules for students and should be against the rules for teachers. I definitely am siding with that view that parents should have the right to determine how their child is going to be punished, especially in terms of physical punishment. I just feel like we don't have any right to do that. I think the lines are way too blurred. It's just too much of a risk to be in schools in general. Some forms of corporal punishment include spanking, paddling, pinching, slapping. I also actually learned that it can also include making someone ingest something, like if they, something spicy or something really too hot, or it can also include restraint. So for special education students with disabilities, restraint practices can also be included in corporal punishment if teachers are not careful. So this is just basically any form of physical punishment intended to cause or inflict physical pain onto someone else. When I looked a little bit deeper, I really wanted to know exactly how the United States are involved with this. How does that look in our country for corporal punishment? So in the book, it tells us if it's not prohibited by the law, by the state law, or the school board policies, reasonable corporal punishment can be used as a disciplinary measure. That's a little confusing within itself just because it just says reasonable. But we have to look at what reasonable versus what unreasonable is. When looking at the history, kind of like the timeline, the background on this, in 1971, only one United States state had prohibited corporal punishment. But if you fast forward a little bit, 2017, 28 states, including Washington, D.C., had prohibited corporal punishment. However, in learning that, it really didn't give me any type of or positive feeling in the fact that we have 50 states in our country. So 28 states in this century is just not a lot for me. I feel like corporal punishment is mainly apparent in southern states and the Midwest. So when I looked a little bit deeper into my research, I found that corporal punishment is still permitted in about 19 states. And then I listed those for us as well. This includes Alabama, Arkansas, Arizona, Colorado, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Missouri, Mississippi, North Carolina, Oklahoma, South Carolina, Tennessee, Texas, and Wyoming. So I was definitely surprised. I honestly did not think that corporal punishment was still permitted in that many states. And surprisingly, I was not surprised to learn that many of these states are in the South. I feel like in a lot of political issues and a lot of controversial issues, the South is definitely more Republican in a lot of these ways. And even if they aren't necessarily Republican, not to make this a political thing, I just feel like we're a little bit slower to advance or to adapt to new policies and procedures that our world is kind of going towards. So I talked about reasonable corporal punishment versus unreasonable. So I looked a little bit more into that. And when I move on, what makes corporal punishment necessarily reasonable? I just feel like that's a very blind term. You really need to know exactly what reasonable versus unreasonable are. And, once these cases start getting involved, it's really hard to even make sense of that legal topic. So to assess whether a certain instance of corporal punishment was reasonable, the courts look at the student in terms of how old they are, their maturity level, and all of their behavioral history, while also combining this with the nature of the student's offense, what kind of instrument was used by the other person who inflicted the punishment, the evidence of any lasting harm to the student, which could be mental, emotional, behavioral, physical, medical. I mean, that could entail a lot of things, and the motivation behind the punishment coming from the person who inflicted it. So when I found that in the book, like I said, it's just very, this is the best way for me to make legal sense of corporal punishment, is the reasonable versus unreasonable, and then also kind of going into different cases where teachers have violated that. But in my research a little bit further, while recognizing that corporal punishment implicates students' constitutionally protected liberty interests, the court emphasized that state remedies are available, such as assault and battery suits, if students are excessively punished by school personnel. That was just crazy to me, just because it's basically saying, so, if the state does allow it, because, the federal level basically gave states that responsibility on their own to handle these cases, all they have as protection is turning around and looking at an assault or battery case. And a lot of times, like in the book, it says that a lot of the times the courts do uphold for the school board. In Ingram versus Wright, which is 1976, about that time, it was a minor at a Florida school who basically just broke a school rule. He refused to get in the paddle position, and then he was forced by his principal to actually get in that paddle position. So through district ruling was to not exceed the paddle over 5 times. So basically he wasn't supposed to get paddled more than 5 times. But it says that Ingram actually received about 20-something paddles. His parents and him, they took this to court. And he argued that this was cruel and unusual and was in violation of his 8th Amendment rights, as well as his due process procedures under the 14th Amendment. It actually made it all the way to the U.S. Supreme Court, in which there was a 5-4 decision that this corporal punishment was not prohibited by the Constitution or the Florida state law, as well as they ruled in favor of the school district in terms of the 14th Amendment and due process. So basically this case was not successful in finding constitutional challenges to the use of unreasonable corporal punishment, which just goes back to what I said earlier about making sense of this legal topic. Is it's blind. There's just too much uncertainty about it. So the court looked at all of this stuff in terms of his age. He was 14, his maturity level, behavioral history. He had gotten in a little bit of trouble, while also looking at the nature of the offense, the instrument used, blah, blah, blah. But they still didn't deem it to be unreasonable or having too many lasting effects or being damaging to this student. When I looked a little bit further, since courts basically give the state that responsibility in choosing where they're going to go on in the corporal punishment, basically teachers get to decide. If the school board has, corporal punishment policies, every school board is different with that. But when teachers decide, I found a court case that really just kind of stood out to me at Herschel Jones Middle School in Paulding County. Basically, this teacher, Miss Baker, she was a first-year teacher. I guess the students were talking. She instructed one of the students to leave the room. And this student, Jonathan Peterson, actually got up and tried to leave the class. Well, Miss Baker tried to block the door. She put her hand up and basically told him to sit down, and he refused. So at that time, the student forcibly removed her hand from the door frame. She says she was pushed. He said he didn't. But basically, he inflicted some sort of physical touch in which she defended that she was acting under self-defense. So what she did then was place her hand on the student's neck for an unknown length of time, in basically a choking position. So this case was definitely interesting. When I was looking, which I quoted it right here, or I got a link. So if you wanted to actually read all the strenuous details about this case, I did include that. But I found a really good quote just to kind of go over the conclusion of this case. It says, although misguided, the teacher's response to the student's misconduct, even if we accept the plaintiff's version of the facts, was not so brutal or inhumane as to shock the judicial conscience. Nor can it fairly be said, in the light of the student's behavior, that the teacher's conduct was based on actual malice or an intent to injure. So basically, this teacher was entitled immunity under the state law since she was trying to gain control of the student who had already shown unnecessary force. He tried to leave the room. He actually physically stepped forward first. So the court found that she was not displaying unreasonable punishment in terms of, what exactly the punishment was, her motivation behind that, and then the student's behavior and the whole circumstance. In the book, it says, beyond statutory or board restrictions, school employees can be charged with criminal assaults and battery, which might result in fines and or imprisonment. That's another reason that I'm saying, I just really feel like this is just not something that belongs in schools. If it can get to that level, I just feel like it's too confusing and nobody really has a clear understanding of what that entails. Everybody's different, and you just don't want that that possibility happening. So because of these blurred lines, it just shouldn't be a thing. Parents, like I said, should be responsible for deciding this. In the book, it does say that if teachers do decide to use this, or if it is allowed based on their school board policies or their district policies or their state, that they should keep detailed records and they should follow the minimum procedural safeguards. They should notify all the appropriate individuals, definitely including notifying the child who is doing whatever behavior that teacher thinks warrants a paddling or any other form of corporal punishment. That's just a basis in disciplining students. I firmly believe that a student doesn't know that they're doing something wrong unless you explicitly tell them. It goes along with our explicit instruction, and you should also explicitly teach rules, and so that kind of goes with that. Teachers should get a witness, such as another teacher, to step in and give parents a written notification statement. So the parents should definitely be notified, and in writing. That always protects anyone, and so that's definitely something that teachers should keep in mind who do practice this. Some student effects. I found an extra video of a former corporal punishment victim in a public Mississippi school. His name was Trey Clayton, which we can watch this video and kind of go more in detail with it. But some highlights that I took out from the video was that Trey basically started off saying that school was fun. He was a good student. He just didn't do his homework. He didn't like being told what to do. Just a lot of minor infractions. And he said he was happiest at school when he was playing football. Well, eventually when he was in 8th grade, there was an incident where he got in trouble. He got paddled. And then on the way back to class, somehow some sort of corporal punishment physical altercation happened with his principal, in which his jaw was broken. He had bitten through his lips or his tongue. Some of his teeth were missing, and his mouth stayed wired shut for 6 weeks. At the time that this happened, he actually they were undergoing 6 weeks tests or 9 weeks test. And they didn't allow him the opportunity to retake his test. So he basically failed that year. It kind of set him off. He didn't want to go to school. The next year he failed again. And basically he just ended up dropping out. He said, there's no sense in me staying and finishing this. He had already failed so many times, and he just had that negative view basically on school and the effect that corporal punishment had on him. That's very important that we promote students' mental health and choose appropriate means of consequences and punishment. And so I definitely think that looking into this legal topic helped me make sense of that by using the unreasonable versus reasonable kind of support that Supreme Court gives in the Ingram versus Wright case. So